Thank you, Presiding Officer. Let me start by saying I very much welcomed the referral by the Justice Secretary in 2007 of this whole issue to the Scots Law Commission. That was an important step in taking forward a matter that we had debated and engaged in this place for some time. But of course the principle of ne bis in idem, or in French, autrefois convi, has been in Scots law for some 800 years, and it's worth returning and thinking of what kind of world was it. The English had been conquered by the Normans at that time. Scotland had, however, yet to face down the substantial challenge that Edward I would bring 100 or plus years later. A very different world, a very different approach to legal matters, for that matter. So the fact that this principle has endured over such a lengthy period should put us very substantially on notice that this is not a matter to be treated trivially. It is a matter of the utmost seriousness, because it has been at the centre point of Scots law and the law of many other countries for a very, very long time indeed. I think for my part, and I suspect for the part of others here, one of the most chilling speeches made to this Parliament was by the Lord Advocate on the matter of the World Ends Murder. It was a very lengthy speech. It was one that left the chamber as quiet as I have ever heard it. And there was no fidgeting. There was a stillness among us as we had matters laid out before us in a judicial manner by the Lord Advocate that we're not used to. And I think if we listened to that statement, and I think some people found it sufficiently disturbing they didn't stay for the whole statement, then we understand the issue. And I think Cathy Craigie in particular was absolutely right, and I think was the first person in this debate to focus on the issues of the victims of crime. Because, of course, this is not simply about identifying the crimes of someone, ensuring that an appropriate punishment is put in place. It is about serving the interests of those who have been affected by crime. So in considering whether, after 800 years, we should be looking at this again, there are very substantial issues indeed that we have to consider. For me, having served on 2 Justice Committees previously in this Parliament, and having spoken on this subject previously, it is a welcome opportunity to revisit it. And of course, revisitation is the whole point of what we're debating today. It could be argued that it is somewhat strange that trials can be restarted for a whole variety of reasons up to the point of decision. But after the point of decision, it is absolute, it's inviolate, and you cannot revisit it. And I think we've now moved beyond the point of accepting that that is the thing, but equally we've accepted that it is no small thing to do so. The English example does show us that the criminal justice system and the interests of justice does not collapse when you introduce such a measure, so I think that can give us some substantial confidence that it is worth our while proceeding in this way. Now, clearly, there are other ways in which the ends of justice can be served. We've observed, I think, with varying degrees of interest and engagement, the use, following a civil trial, of the law of perjury for one of the former tenants of this particular premise. So clearly there are other ways in which the interests of justice can be served. And clearly, if someone has been prosecuted, if someone has not been found guilty, and let's not forget, people are found not guilty, they are not found innocent at any stage, although the presumption is they are innocent. There are other ways that can be used, and the law of perjury is always one that could be used. But of course, it's not an easy thing to deal with. Now, what tests are we putting in place? Are they sufficient? Are they adequate? Clearly, the hearing that must precede any re-prosecution is absolutely an important part of the changes that we are contemplating here. In particular, I think we would all recognise, for example, that not all confessions are sincerely made. There will be instances, I suspect, of people who are clearly engaged in criminality, may already have substantial criminal records, who, because they're publishing a book or have the opportunity to be paid large sums of money by one of the tabloid newspapers, embellish a tale to the point of confessing to crimes which they may or may not actually have committed. So therefore, for that reason alone, and for many other reasons, the hearing process is very important to test whether it is possible in the interests of justice to contemplate a re-prosecution. And of course, it's equally important that the person who may be subject to that new prosecution has the right of appearance there and has the right to be represented. So these are important provisions that are in the bill that's before us. We've had some exchanges, and I suspect as the bill runs through Parliament we'll continue to have, as to what scope we should limit this to. Should it only to be on original prosecutions on indictment? Should it be on summary? Robert Brown perfectly properly said it's pretty unlikely that there would be a trial on indictment where evidence came forward that would have been likely I beg your pardon, on summary, that would have been likely to have caused it to be on indictment in the first instance, when it was in summary in the first instance. But certainly we can't exclude that. And if we're thinking of the victims, then I think we need to think very carefully about where we strike the balance. Now, there are some things not in the bill, which I don't think sensibly could be in the bill, that nonetheless it's worth having a think about. For example, should we be able to re-prosecute people who've actually subsequently died? Now, that might seem slightly amusing in a sense, but the reality is, of course, that having a court case prosecuting somebody, and it can be done in other jurisdictions, who's dead, does actually serve the interests of justice in certain instances and serves the interests of the victims. But it's a very, very, very difficult thing to contemplate, and I think this relatively modest-sized bill would be substantially greater if we were to contemplate that sort of thing. But I bring that up just for us to consider that don't imagine we're solving every issue that there is surrounding this. Some people are denied the opportunity. He certainly will.
Robert Brown. I'm not quite clear what Mr Stevenson has in mind there, but I wonder if he's thinking of the McGrathie case and the situation under which the purported death of Mr McGrathie in due course would have interrupted the re-review of the proceedings, and does he think that there was an issue arising out of that where the victims, in a sense, were deprived of the opportunity to test the issues before the Court of Criminal, the Appeal Court, following on the Criminal Cases Review Commission?
I think the member cites a perfectly reasonable example. There would, of course, be others. Now, of course, there are other ways in which the issue can be dealt with besides having a retrial in the criminal court. But I think it is clear that the victims very often don't regard that as equivalent to prosecution in the criminal court. But as I say, that's a matter which is not in the bill, Presiding Officer, and I would not wish to have you draw me up too tightly for speaking on a matter which is not strictly before us today. Let me just turn to one or two of the things that are in the bill, and something that has been referred to in the debate so far, and that is in the relation to acquittals where there's been interference with the jury. At section 2, paragraph 5, one of the exceptions, it says, but the acquittal is not to be set aside if in the course of the trial the interference, being interference with the juror and not the trial judge, became known to the trial judge, who then allowed the trial to proceed to its conclusion. Superficially, that looks okay, but the reality is, of course, the effects of that interference might be greater than the trial judge was aware of at the time the trial judge allowed the trial to proceed to its conclusion. So I think that may be something that those who will take this bill forward might wish to look again at if that part of the bill is to be retained. Because one juror being, quote, nobbled, that juror may have contaminated other jurors and put other jurors in a state of fear and alarm before being removed from the trial, and the judge may have not been in sufficient possession of the facts to realise that that has happened. So I think just as almost everything that a judge decides can be reviewed elsewhere, I think to exclude a review of a judicial decision in relation to allowing a trial to continue after a jury has been, quote, nobbled, may be an exclusion too far. Now, turning to the committee's report, and, Presiding Officer, I am conscious we have a certain amount of time, so I will continue on if permitted, at paragraph 33, one of the issues that the Scottish Human Rights Committee and the Law Society raised was what standard of proof there should be, and raised the point that at the hearing it should be beyond reasonable doubt. And of course that wouldn't necessarily be the case in an original prosecution. It would be for the Procurator Fiscal to consider a lower test, a reasonable prospect of a conviction. So I think that's an important thing to bear in mind. Also at paragraph 48, the Human Rights Commission and John Scott talked about the range of serious offences. And I think it's very important to test, as the bill goes forward, that we're able to combine new charges with retrial of old charges in a way that will serve the interests of justice. And I hope that members who take that forward will do that. The committee has considered at some great length the issue of retrospective application of the Act, and like others, instinctively that's not something with which I'm comfortable. But in this particular case, I think it would leave a huge gap in the opportunities to deliver justice for many people if we were not to have the opportunity to revisit trials that went in the past. Now, I previously made interventions on the subject essentially of extradition, and I do think there remains a substantial issue there, that we now have a variety of ways in which people may be extradited to other jurisdictions within the European Union and to the United States without there being any necessity of showing that there is a case to answer. That is a matter for the jurisdiction to which the extradition takes place. And in the case where someone has already been found not guilty in the Scottish court, I think there is an enduring potential for injustice in that respect. But of course, the law in respect of extradition lies elsewhere, and it is not at our hand. I do look at section 10, subsection 3, which relates to Article 54 of the Schengen Convention, which it touches on some of this. I have to say I had previously only been aware of the Schengen Convention in relation to the UK being outside the common travel area created by Schengen, much to travellers' inconvenience. I will clearly go and read it and discover what other delights there are within the Schengen Convention. Let me congratulate the Government and all who have pressed for this on bringing forward this very excellent bill. It will serve the interests of justice, it will serve the interests of victims, and it will give great fascination to those of us who are interested in the minutiae of legal legislation. Presiding Officer.